staff, management, or sponsors.
Welcome to the Ask the Experts show with local experts in the fields of legal, health, financial, and home improvement. Enjoy being educated in such topics as personal injury law, community association law, family law, bankruptcy law, along with health show topics like pain management, men's health, and dental implants. Now, sit back and enjoy today's Ask the Experts with host Steve-O.
Hey, good morning. No, not morning. God, morning's so easy to say. Easier than saying good evening, but good evening, everybody. This is the Ask the Expert show. I am your host, Steve-O. We are on every Thursday night from 6 to 7 drive time. This is the first Thursday of the month. It means our community association show, who has been with us for 4 years now, Kay Bender Rimbaum. And we have our big star, Robert Kay, attorney Robert Kay, certified attorney Robert Kay. And hey, Robert, I told you today, I cannot believe the questions that everybody has.
I mean, it's an interesting time, and good afternoon, everybody.
Well, it just shows you the amount of listeners that we have, and they're basically, many of them are scared. And so I'm going to ask you, yes, and so I'm going to, as soon as we introduce everybody to you and tell everybody about your firm, and we've already got calls coming in. The phone number here is 888-565-1470. Just give us a few minutes while Robert tells us about Kay Bender Rimbaum.
Well, Kay Bender Rimbaum is a full-service law firm that concentrates in the area of community association law. We have 3 offices in Florida, one in Pompano Beach, our main office, Palm Beach Gardens, and in Tampa. And through those offices, we provide all of the general legal services needs to community associations throughout Florida, dealing with covenant enforcement, interpretation of the documents, advisory opinions, contract negotiation, collection of unpaid assessments, litigation, defense, construction defect issues, across the board, whatever community associations deal with every day. We're there to provide that kind of assistance. Have been since 1992.
Well, before I delve into this, I want to take we have a caller from Orlando, Rodney. Are you there, Rodney?
Good evening.
How are you?
I'm doing well. Can you hear me okay?
We can hear you fine.
Great. I had a question regarding architectural guidelines. The community is about 30 years old, and we have the declarations, bylaws, those documents, but we've never had any type of architectural guidelines for like fences or pavers and any improvements like that. Can the board implement those, put those together and implement them, or does it require a vote of the association, the members?
Are you a homeowner association, Rodney?
Yes, it is. Small community, about 80 homes.
Okay, well, the provisions of Chapter 720 on this topic do suggest that the association needs to have architectural specifications in place in an objective format, meaning in written form, that anybody can see and know what they're supposed to do based upon that. Whether or not the board can adopt it or it takes an amendment and a vote of the members is going to depend on your documents as they're currently written. Most communities do empower the board to create these. Sometimes they delegate to an architectural control committee. Sometimes it requires an owner vote and an amendment to the documents. Your documents have to be reviewed by an attorney who understands the area of law and can give you the best guidance as to whether or not you need to do anything other than just have the board adopt these new specifications.
Okay, all righty. Yeah, we had read through everything, and they spoke to the architectural committee, reviewing applications and things like that, but there were no powers given as far as adopting any type of guidelines or anything like that. So that's
most
a
likely
little tricky.
You're going to look for the powers of the board of directors throughout the documents, either in the declaration or in the bylaws, as to whether or not the board is empowered to adopt rules governing the use of the residential properties, which would include the ability to make these architectural control standards.
Okay. All righty then. Well, we'll dig down a little bit further, and then may have to reach out to you for some legal assistance then.
Okay, Rodney. Good luck.
All right.
Thank
you
Rodney.
very much for your help.
Thanks for listening.
Let's go to Donna in Weston. Hi, Donna.
Hello. I'm calling about, this is a condo association, and we're a new board, and we have a current rule that four people can live in a unit, and if they're a licensed driver, they could have 4 cars. The board would like to change this that they could only have 2 cars. We realize we probably would have to grandfather the people in that already have 4 cars or 3. But can the board just make this decision, a new rule, that they could only have 2 cars from now on?
Are you saying that it currently exists in the rules, or is it in the declaration as to the number of cars that are
It's
allowed?
only in the rules. In the documents, it says 1.5 car spaces for each unit. Of course, parking is a problem. We don't have enough parking spaces, so that's why we're trying to change this rule for future.
Well,
use.
it's possible that
per unit.
it's possible from what you've described that your rule may not be in conformity with what your documents provide. If there's a limitation, well, 1.5 car spaces per unit doesn't really provide for the type of guidance that you need, because you can't have a half a car. So,
Right.
if the
But can
rule
board
allows
make a
for
decision
up
just
to,
to change it to 2?
again, that's going to depend on the powers that the board has that are specified in your documents. And if the board is empowered to make rules and regulations governing the use of the property, which would include the parking area, that would be something the board could change. Now, yes, and when you make a rule change, when you make a rule change, it's not retroactive in its application. It only applies to what happens after the rule is adopted. So you are correct that existing situations would likely have to be allowed to continue unless you adopt an amendment to your declaration of condominium that provides for the limitation. And in that instance, you could make it effective as to all vehicles as it currently exists, and some would have to leave.
Right, I see. Okay, well, that answers the question. So, and I appreciate your help. Thank you.
Sure thing,
Thanks,
Donna.
Donna.
Thanks for listening.
Thank you. Bye now.
So, Robert, a big question we got is, Miami at the high rise, it's been in the paper that it was going to cost every one of the residents there $80,000 to $90,000 to make these changes. And there was listeners who wanted to know, what if they don't have the money? What do they do?
Well, that is a very big problem that exists in many communities. For those that are newer and those that are in better condition, we suggest that it's prudent for the board to rethink some of the past policies that they may have had in place about waiving reserves every year. Having full reserves in place does provide some protection to associations that are facing significant costs of repairs, maintenance, and things of that nature. But if you don't have that, obviously you have to start somewhere. So it's a good idea to make sure those reserves aren't waived fully or at all going forward. In situations when you're facing a massive repair cost that could be to the tune of $90,000 to $100,000 per unit, you don't really have the option of not doing it. It's the obligation of the board, the fiduciary duty to the entire membership to undertake the maintenance. You would have to find alternative means of financing if possible. It can be a difficult conundrum for a community that has high delinquencies because they typically don't qualify for loans of that nature. And then if you assess everybody, you're not going to collect the money. So it's kind of a rock and a hard place situation. It's best to get a handle on the conditions of your building sooner rather than later. Don't let it sit around. A big problem we face in these condominium associations is board members are not necessarily trained or experts in the area. There are other residents of the community, volunteers. They do need to get involved with high quality management, high quality engineering, high quality attorneys to make sure that they're doing everything possible to protect their buildings and to make sure they're not going to be facing these massive repair costs that they can't afford. There is no real strong answer for those that are facing it other than you have to do what you have to do.
Yes. Let's go to Lois in Boynton. Hi, Lois.
Hi. I have a question. This is an HOA question. We have a compliance committee. We had a case that came to the compliance committee, and we made a recommendation to the board. The board amended that motion, and they added to it. The defendant got up and said that she accepts what the board's new motion, but the president of the association said that according to 720, we had to have a hearing, and he chose 3 members for the hearing. Well, the defendant didn't ask for a hearing. She was in agreement with what the board decided. But they went ahead and had this hearing anyway, and it just seems to me that if the board is making a motion and then they're hearing their same motion, it just doesn't make sense. But the president said that he had spoken to a lawyer, and they said that they had to go ahead with a hearing committee anyway. But then one of the men that was chosen as one of the 3 for the hearing committee said he spoke to a couple of lawyers, and it was the 720 is very ambiguous about that. What do you think about?
Well, the way 720 reads on this is pretty much the same as 718 and 719 for condominiums and cooperatives, is that in order for a fine to be valid and basically incurred against the property and the owner, there has to be a hearing on the fine by a committee that's made up of individuals who aren't board members, aren't family members of board members. And the function of those individuals is to say either yes or no that the fine being requested by the board based upon the information that's presented at this hearing is going to be imposed.
But if
in a situation as you've described, in the situation that you've described where the board has identified a problem, said we want a fine on this, and the owner agrees and says that he or she is going to pay, then it certainly isn't necessary to go forward with a committee hearing if it's already resolved. The purpose of fining is a method of enforcement. It's not necessarily a means to collect money or embarrass people. It's to get whatever violation is resolved. And in your situation, the owner indicated a willingness to comply and pay whatever fine the board was thinking about. So it seemed like
it was actually a consequence. It was a consequence. It wasn't a monetary value, but she agreed to it. So,
Right. So
we couldn't understand why they went ahead and had to have this hearing when she already agreed to it.
the only thing I could think of is perhaps for the association's records to show that it followed the procedure, and also to protect it for future situations of a similar nature, that somebody wouldn't come back and say you were not uniformly following the law on this, and could be risking a challenge of waiver or possible inability to do it in the future. So
we think that the 720 or 718, I don't know what you're referring to, but we referred to 720, and it didn't say that a hearing had to be, especially if she already agreed that she would take whatever consequence it was. It wasn't a monetary thing, but
well, I don't disagree with you that I don't disagree with you that in the situation you described, it was not a necessity to do.
Right. Okay. Well, I just thought maybe we were interpreting 720 differently than maybe a lawyer, would interpret it.
Well, what I was referring to was fining. In a consequence situation, the only other consequence that the statute talks about is suspension of use rights. I'm not sure what other consequence would fall into
right. Well,
this.
The consequence was for her not to be on any committee and be a voting member.
Well, that really is outside the scope
agreed.
of the statute anyway. That's outside the scope, and it's just an agreement between the association and an owner to resolve a dispute.
Right.
So
okay,
no
that's what I
hearing
thought.
is required for that.
Okay.
I appreciate it. Thank you.
Thank you. Robert, we got to go to break. Give everybody the phone number and your website address.
You can reach us at 800-974-0680 or go to kbrlegal.com. You can send an email to info@kbrlegal.com.
And we have one line open. We're going to go to break. The phone number here is 888-565-1470. 888-565-1470. We come back, we're going to be talking about the schedule for July. We'll be right back.
K. Bender Rembaum is a full-service community association law firm dedicated to the representation of community associations throughout Florida, with offices in Pompano Beach, Palm Beach Gardens, Tampa, as well as in Miami-Dade by appointment. Several K. Bender Rembaum attorneys are board-certified specialists in condominium and plan development law, and they assist clients with all matters of community association legal issues while keeping them up to date on new developments affecting their associations. K. Bender Rembaum is also a well-known provider of free legal education, which often includes CE credit for managers and state certifications for board members. Contact K. Bender Rembaum today by calling 800-974-0680. That's 800-974-0680 to reach any of their locations. You can also visit them online at kbrlegal.com or just write to them via email at info@kbrlegal.com.
And we are back. This is the Ask the Expert Show. We have been broadcasting for almost 7 years now. Thursday night, 6 to 7 during drive time. And Attorney Robert K. is with us tonight of K. Bender Rembaum. Before we go to the schedule, have your phones been ringing more this week than normal from your clients?
I wouldn't say that the phones are ringing more than normal, but there's a lot of scared people out there thinking that they're at risk of a similar situation. I think we have a situation that's unique and somewhat of a freak situation with what happened at this particular building. It's unprecedented. It's never happened before. And the chances of it happening again are significantly remote, but that doesn't mean steps should not be taken to make sure that the building is structurally sound at all times, of course.
Is there a way to, I heard several people say they kept telling the property that there was a problem and they weren't getting any response. Is there a better way if you think there's a problem? Do they talk to the board about it?
Certainly, the board should receive certified mail from any unit owner who thinks there's a situation that needs to be investigated. If the board is aware but not taking steps that are necessary, there is local building departments with code enforcement that you can make a report to, and then the city or county can come out and give an indication of the complaint and possible investigation. But boards should be responsive to those types of inquiries so long as there's a reasonable factual basis for it. You can't just make the claim without something to back it up.
That makes perfect sense. We have a caller on the phone. I'm going to get to her, and then we're going to go to your schedule. Her name is Maria in Fort Lauderdale.
Hello, Maria.
Hi, Maria.
Hello. I live in a homeowner association, and we have a member of the board who has been serving for 10 years. And in the recent 2 years, the board has been elected. There has not been quorum, so it has been rollover, the same board. Is there anything that the board can do to replace that member, even if there are not elections or no quorum?
Well, unfortunately, the only way a board member can be removed is by a vote of the owners, and that's either at an election or by recall. And if there isn't enough volunteers that are willing to serve on the board, removing a board member without replacement could create a problem. But in order to remove a board member by recall, you'll need a written agreement signed by at least a majority of all of the voting representatives within the association. You have to know from your documents whether or not you need voting certificates to appoint a designated voter if there's more than one owner, or if it's a ownership by an entity such as a corporation, an LLC, or a trust. And in those instances, you have to get the right person to sign on the agreement and have at least a majority of those to remove any member of the board, which has to be done not sooner than 60 days after the annual election or 60 days before the annual election.
Okay, but is there such a thing as a maximum of 8-year term for a member of the board?
That's a provision in the condominium statute. It's not in the homeowner association statute. And in the condominium statute, that was adopted in 2018, July of 2018. And so it started July 1, 2018, which means the 8 years don't run until June 30th of 2026. And again, that's just for condominiums.
Oh, thank you so much. Got it.
Thanks, Maria.
All right, thanks for listening.
Let's talk about your schedule for July.
Well, we have some good things coming up. Apropos of what's going on with the building, next week, July the 7th, Tuesday, at noon to 1 o'clock, sponsored by Castle, we have Association Leadership Building Maintenance Best Practices with Jeff Rambam and Lisa McGill, and of course Castle and engineer Tim Marshall from AT Designs. That's going to be a very informative hour at 12 noon on July the 7th via Zoom. Again, for all of our Zoom webinars, you go to kbrlegal.com and click on the KBR calendar, and then choose the item to reserve your spot so that you can get the information to log in. On July 21st, Association Leadership Episode 20, hosted by Campbell Property Management. I'm sorry, this is the Castle Group again. Michael Bender and Jeffrey Rembam will be talking about general issues that are facing community associations and association leadership. July the 21st at 12 noon. July 22nd at 12 noon. We have a condominium and HOA board member certification. That's going to be a combination meeting at 12 noon to 3 o'clock. Andrew Black will be teaching that course. It's going to be hosted by Rio Manage. So that's a combination condo and HOA board certification. Then on July the 28th, 11 o'clock to 12 noon, the screening process, how to develop procedures and train your committee in reviewing applications for sale and lease. Andrew Black will be teaching that. It's hosted by Affinity Management, 11 to 12 on July the 28th. And then August the 5th at 12 noon to 1 p.m., funding construction projects with Michael Bender, hosted by Castle Management, 12 noon to 1 p.m. on August the 5th. And
Wow.
That's what I've got on the schedule coming up.
Okay. Well, if you'd like to call in, our phone number here is 888-565-1470. I wanted to do a follow-up question before about some of the phone calls you've gotten about, I guess, older properties that are concerned. What have you been telling your clients?
Well, there's such a wide range of issues to be addressing. We need to be more specific as to what we're telling them. They need to have regular reviews of all of the components of their building by independent experts, engineers. The time frame to do that is probably within 3 years to 5, no later than 5. But certainly by 3 years apart, to do a thorough examination of the structural components of the buildings, particularly in light of what's happened last week.
Right. Well, that
also,
makes sense.
Periodic reserve studies should be undertaken by independent experts to identify the useful life of the various components that reserves are required for, and to help you set up and maintain a proper schedule of reserves. And we also suggest that for condominium associations where the board has the discretion whether or not to offer a waiver of reserves, not to offer that as an option, but to fully fund reserves as the statute requires.
Okay. Well, if you have a question for Attorney Robert Kay, the phone number here is 888-565-1470. We also take your emails, which you can find our email address on our Facebook account. It's Steve-O. It's Ask the Experts, host Steve-O. And a lot of people that are driving home from the 6 to 7 hour don't like talking in their car, so they send us emails, and we get a ton of emails. Here's one from Robert in Pompano. We are in a condo, and the board of directors has decided to put some kind of tenting up for termites, and they have asked us to leave for 3 days. Several of the people do not want to leave their unit. What do we do?
Well, when you're tenting for termites, individuals cannot stay in the building because they, like the termites, will die. So they have to leave. They cannot stay. If owners refuse to stay, then that leaves the board with no option but to bring the courts in and file a lawsuit and get an injunction to compel the owners to vacate the property during the time that the tenting is going to take place. Unfortunately, the courts don't move as fast as the termites do, so there may be some damage that could happen to the building during that delay. It's very important for all of the owners to cooperate with the board and make sure that you prepare your unit properly in accordance with the instructions you get from the provider, and be sure to vacate for the entire time that the extermination process is going on.
Okay, I wanted to get this in because it's a board member. Kim and Davey says, I'm a board member. I love your show. All my board members listen to your show. We are a condo. We are responsible for roof repairs. Our roof is 30 years old. Is a 30-year-old roof still insurable?
Well, that's going to depend on the insurance carrier. I think that it is insurable, but it might be at a higher premium. The insurance carriers are dropping policies left and right in Florida, as we know. I understand the governor just vetoed some insurance legislation, but that was more for automobiles. There was topics that were presented this year that did not pass that was intended to appease some of the insurance carriers. There were some things that did pass. The 30-year roof issue could be a problem, not only from insurance, but from its capability to withstand a storm or even in general normal rainstorm. So certainly that should be carefully checked.
Here's from Justin in Boca. Our management company just told us that our final year-end report from the CPA firm will not make the deadline. Does the board have a duty to let everyone know? What do? We are a condo association.
Well, it is not unusual for accounting firms not to make the deadline that the statute sets forth for the annual financial statements from the prior year. And while the board does not have a legal duty to let the owners know of the delay, there's no reason why it could not. If they want to communicate to the owners that while you provided the information timely to your accounting firm, it's going to be delayed, and as soon as it's available, it'll be shared as required. I don't see it as a major issue, particularly when it's out of the hands of the board to control.
You know, Robert, we had a lot of letters from people that had concerns that they weren't getting notifications about fees that were due. And I just saw, this is Becky in Boca. She said, I live in an HOA. Is our board obligated in the statutes which require a notice when payment is due? Shouldn't that be spelled out somewhere?
Well, the only notice that is required is the annual budget. And that annual budget informs the owners what's required. Now, many communities do provide periodic statements to their owners, and the statutes, all three, were changed this year, effective today, to require, if there is a notice that's sent, then where it has to go, and if it's ever going to change the method, there's a whole procedure that is going to have to be followed in order to change that method. So obviously you want to keep it as much as the same. It also requires an owner to sign off on the change before it can be effective, which can be problematic, particularly when owners don't respond at all.
Right.
It's going to be an administrative nightmare for a great many associations without really any benefit to anybody. But that's the state of the law. So the straight answer to the question is no, there's no legal obligation for the association to send periodic notices of what's due unless it's delinquent. Now, if it becomes delinquent, the new statutes require there be a 30-day notice sent by the association before any attorney's fees can be incurred in the collection process. So all associations have to be doing that. So there'll be a notice at that point, so without attorney's fees attached to it. And then there'll be a 30-day time period to bring the account current. Thereafter, all of the time frames have been adjusted, 45 days instead of 30 for condominiums and cooperatives. It was 45 days before for homeowners association on both the first notice of intent to lien and then the second notice of intent to foreclose. Those are the changes that went into effect as of today.
Okay. If you'd like to give us a call here, the phone number is 888-565-1470. We have a line open. This is from Ashley in Boca. She is an HOA. She said, our president and property manager decided to remove a tree without a permit. The landscaper did not meet the code qualifications, so we are being fined for that. We are worried about other fines that have happened. Can we see a copy of all bills paid for the last 12 months if we think our property is being mismanaged?
Well, all of the official records of the association are open to the inspection and copying by any owner upon written request for an appointment to do so. Included within these records are the financial records, which will include the expenditures that the association has made during the course of the period that you're looking to inspect. If you want to see a year, that should be there. So you have to send a notice in writing of a request for inspection. You have to be aware whether or not your community requires such a request to be by certified mail or not, because some do, and that's considered acceptable. And then from that point, the board will have 10 business days to provide you with that access.
Okay. Zaza in Palm Beach, she said, I live in a condo where we have no pets allowed, even though there are rules for support animals. What are the rules on a second dog? Can they call that a support animal also?
Well, the federal fair housing laws, and as well as the state fair housing laws, are not specific as a limitation as to how many support animals will qualify to assist the individual in need, and many have more than one. Each support animal has to satisfy the same requirements of having a written notification of support from a medical provider of the specific need for that particular animal to alleviate whatever condition it is that impairs a major life function. And once those criteria are satisfied for each animal, there can be multiple animals.
Okay. This is one I love doing. It says, I love you. This is from Ashley in Deerfield. She said, I love your show. I never miss one. Just wish you were on more. Okay. You got to be on more. The homeowners, we're a HOA. Homeowner is delinquent. They're trying to sell it must be a condo. They're trying to sell their condo. Will the title company make the buyer aware of what is owed on the property?
Well, typically, if there's a title company involved, they will contact the association with what's called a request for an estoppel, in which the association will answer certain statutory questions, among which is an amount that's outstanding and delinquent to the association. And typically, those funds will be collected and paid to the association during the closing process when the sale is completed. So the problem occurs when people sell their units without using title companies or doing it in a professional fashion. Sometimes someone just issues a deed to somebody else, no questions are asked, then both the prior and the new owner are obligated to the association for everything that has come due on that unit at that point and into the future.
Robert, we had a lot of people writing, when I say a lot, 4 or 5 people who wrote about board members not ever showing up for meetings and how they can basically get rid of them. What do they have to do?
Well, many of our communities have adopted amendments or have had in their documents a provision that indicates if a board member misses a certain number of consecutive meetings that are unexcused, that would constitute a resignation by that board member, and then there's a vacancy for the board to fill. In the absence of a provision such as that in the documents, then the only method of removal, as I mentioned earlier, is through recall or through at the next election.
What if they want to question one of the board of directors? What do they have to do?
In a condominium, the statute allows for anyone to send a written inquiry, which they have to send by certified mail, and the board is supposed to respond to the inquiry with a substantive response within 30 days, or if it's referred to the association attorney, they get another 30 days, but they do have to let them know it's been referred within the first 30 days. So that would be one method. Sometimes board members are not as responsive as they like. Depending on the issue, an owner can go to the Division of Condominiums and get some assistance with them, or alternatively bring in an attorney to make the inquiry on their behalf of a more formal nature. Sometimes attorneys get better responses than individuals do on their own.
You know, we had several listeners tell us that time of day they're in the car, they don't get to hear your schedule if we could start doing it more often. So can you just go over your schedule again for July?
Yeah, let's do it. Next Tuesday, is it Tuesday or when? Oh, Wednesday, July the 7th is Wednesday. At 12 noon to 1 p.m., Association Leadership, in conjunction with Castle Management, will be doing a special presentation, Building Maintenance Best Practices, with Attorney Jeff Rembaum, Lisa McGill, and an engineer, Tim Marshall from A1 Design, along with Craig Vaughn from Castle Management. Then on July 21 at 12 noon to 1 p.m., we have Association Leadership Episode 20. It's a regular Zoom setting with Castle Group. Michael Bender and Jeff Rembaum will be discussing a variety of issues during that hour, and a lot of that comes from the participants who are watching. On July the 22nd at 12 noon to 3 p.m., we have a condominium and HOA board member certification by Andrew Black. There is continuing education credits for this. It's hosted by Royal Management, I think. It's cut off on my page. On July the 28th, we have at 11 a.m. to 12 noon a Zoom presentation on the screening process, how to develop procedures and train your committee on reviewing sales and lease applications. That's at 11 o'clock to 12 noon. Andrew Black will be presenting with Affinity Management as the host. And then we have one in August. I'm not sure if I'm going to talk to you before that. So August the 5th at 12 noon, funding construction projects with Michael Bender and the Castle Group. There is continuing education for managers on that as well, 12 noon to 1 p.m. on August the 5th. That's a good one in conjunction with your earlier question about communities facing major reconstruction issues and not having the money to address it. So that'll be on August the 5th. You can find all of our courses and upcoming events on KBR Legal on our calendar page. Click on the item that you're interested in and register so you can get the sign-in credentials and participate in the presentation.
If you live in a condo or HOA, or you're a board member, or you're a management company, you have a question for Attorney Robert Kay. The phone number here is 888-565-1470. That's 888-565-1470. We still have about 10 minutes left. Going back to our questions, Ken in Palm Beach Gardens, about a line of credit. Do we have to have 75% vote for a line of credit?
Well, in that situation, it's going to be document specific. Some documents allow the board to borrow funds without a vote of the owners. Some require owner approval. So you got to check your documents in order to know that. I would not do that without the assistance of an attorney who understands this particular area of the law, because you don't want to make a misstep and commit to a big loan when you then need an owner approval and you haven't gotten one.
You know, when you do your ask the lawyer, ask the attorney, and people come in with questions, and it's so funny how others, I mean, people who had their questions, all of a sudden, after hearing others, they have additional questions. It's kind of like what happens here also. And we get a lot of people calling about mold in their units and the board refusing to act. What should they do? Should they take them to arbitration?
Mold is a difficult problem because most of the insurance policies have mold exclusions. Sometimes the mold, if it's in the unit, you have to determine the source in order to determine the responsibility. Associations are going to have responsibility for common elements regardless of all of that. So everything has to be evaluated and reviewed quickly. When the board receives notice of a mold claim, it really needs to jump on it. Because the way mold progresses, damages can get greater and greater relatively quickly. And if the association does not act quickly, then they can be found negligent just from that, which could add to their exposure on the liability. So investigation is paramount initially. You have to find the source of the water intrusion that's causing the mold to happen. Once that's determined, you got to make sure to eliminate that right away. Then it's an evaluation of who's responsible for what. You're going to need your attorney to review with your documents who's going to have responsibility for what aspect under the circumstances. But you can't just sit back. If the board does nothing, then the owner needs to get an attorney and take it to court. Arbitration, as of July 1 of this year, is an option but no longer mandatory for condominiums and cooperatives. The courts are once again open to communities to address these types of disputes, and that's considered a very good thing.
Okay. We have Teresa on the line from St. Augustine. Hi, Teresa.
Hi, how are you?
Good. You have a question for Attorney Robert Kay?
Yes, I do. Regarding to a condominium, and if a person moves in for a condominium like 3 or 4 months, after 3 or 4 months, they find out one of the bedrooms had kind of mildew or mold. And she said she had inspection, like a home inspection, but nothing was indicate some problem of the outside structure. So I'm wondering why that one of her room will feel like mildew. I mean, see kind of mildew look situation, and how would the association remedy this situation?
Well, it's possible for a mildewy or mold type situation to develop within the 3 months and might not have been in existence prior to the time that the inspection was done. It's also possible that because it had been so dry during the winter months and into the spring this year, there wasn't enough rain to create the situation, and that could be why it might have been missed. But bring it to the attention of the association. They need to do an investigation as to the source of any water intrusion, whether it be from the common elements or not. If there's no common element source, there could be something within the unit that's leaking that's creating the problem. So the owner needs to undertake an inspection within the unit of somebody qualified for mold remediation and identification of these types of issues. Once you've identified the source, then you have to work out who's responsible for what. And this owner may need to have an attorney assisting him or her in addressing the association if they're not really doing anything about it.
I see. Okay, thank you.
All right, thanks for
So-
listening.
Robert, I got to share this with you. I just got a text. She doesn't say which property she's at, but she said, "We play your show every month in the card room, and we love your show. Just wanted to tell you." So you're in the card room. Yeah, you're in the card room. We still have a few more minutes. Vivian in Boca Raton, I guess she wants to know, HOA can amend their documents to allow capital contributions. Can condos do the same?
Well, capital contributions is an issue that has become a bit controversial as to condominiums. While many developers have included them in their documents, and it's typically the first-time buyer that will pay it, communities through the years have amended to provide any sale of a unit requires a capital contribution, meaning an unusual amount of money to be paid to the association one time. The Division of Condominium has issued an opinion that they consider a capital contribution to be a charge that's associated with the transfer of the ownership of a unit, which the statute had limited to $100 until today, when it was increased to $150. Many attorneys throughout the state of Florida agree with that. Many do not. Many believe that the transfer fee that the statute refers to is intended to apply to the application and investigation charges, because other types of charges are not going to be $100 or $150. That's really was more intended to offset the administrative cost of doing the background checks. And the capital contribution is there to provide a source of funding to the association for its ongoing operation. There hasn't been any court decision one way or the other to determine who's right. So for condominiums, the conservative advice is do not incorporate a capital contribution, because the division could find you to be in violation if anyone were to make such a complaint. If somebody wants to take that risk and be the test case, then they can take that on themselves.
Robert, we don't do this a lot, but we got a minute left. We have so many board members who listen to our show. Can you address them why they should have a firm like yours representing them? You can pat yourself on the back.
In addition to the vast amount of experience that the firm offers, And the fact that more than half of our attorneys are board certified by the Florida Bar at this point, in addition to all of that knowledge and experience and ability, we also offer cost-effective and prompt responses to inquiries and communication in a manner that is understandable by the layperson. So service is really what's most important to us, and we're in the service business, and we provide a quick and efficient response to our clients' needs. So
The firm is K. Bender Rimpbaum. Give everybody the phone number before they cut us off.
800-974-0680.
Keep tuning in. We'll see you next week with more Ask the Experts. Thanks, Robert. Great job.
Next month. Bye-bye, everyone.
Thanks for listening to the Ask the Expert Show, featuring interviews with local experts in the fields of legal, health, financial, and home improvement. Call our office at 888-574-6999 to become one of our experts on the show. And tune in again next week for more Ask the Experts with Steve-O.
The opinions expressed on the preceding sponsored program were strictly those of its hosts, guests, and callers, and not necessarily those of this station, its staff, management, or sponsors.
This is the FM Money Talk Radio.